Good morning, everyone, and welcome to day 3 of the Insolvency Conference. Thank you very much for joining us this morning. We've got talks this morning from Ali Tabari and Kirsty White on fraud in 2022, which is, I'm sure, going to be fascinating and relevant. If during the talk, I'm sure there may be, if you have any questions, then please put them in the chat or put them in the Q&A function, and then we will get to as many of them as we possibly can at the end. Ali.
Well, good morning, everyone. Thank you very much for joining us. Our talk today is going to be on the intersection between fraud litigation and insolvency. Fraud obviously is a huge hot topic at the moment. And this talk is not just for people in the insolvency sphere, but also particularly pertinent for those who are claimants in civil fraud actions, try and see what kind of options they might have in the insolvency sphere and how they might get them better results than just running a Part 7 claim through to trial, winning, and then finding that there's actually nothing in the pot at the end for recovery. Kirsty and I talk is going to be lasting about 50 minutes with a bit of time for Q&A at the end. So as Rob said, please do use the Q&A box to type your questions in. For those of you who don't know me, I'm Ali Tabari. I'm 15 years call, and I specialise in fraud and insolvency work here at St Philip's Chambers. And Kirsty has been with Chambers for a number of years. Previously, she worked at a very reputable firm of solicitors as an in-house barrister as well, and she undertakes all aspects of our commercial litigation work as well. Now, I'm going to put some slides up in a moment, which we'll then work through. The good news for you is that you don't need to sit there scribbling notes all the way through it, because we've got a detailed pack of notes with all of the materials and a bit more detail to them, which we can send you after the talk. So for now, perhaps just enjoy your coffee, sit back and enjoy the next hour. Now, I will be sharing slides in just a moment. There we are. I love it when the tech eventually works. So this is the talk, the insolvency angle, and here's what we're going to be discussing today. 4 broad topics. The first is causes of action and office holder powers. So it's the usual suite of insolvency actions and how they can impact you positively, hopefully, in a fraud action, unless you're the fraudster. Then we're going to be talking about disqualification proceedings, and you might be thinking to yourself, what's disqualification proceedings got to do with better results in fraud? Well, hopefully Kirsty will be able to talk you through the possibilities there. I'll then be talking a little bit about crypto assets. I'm not going to be starting from the beginning and saying this is what a crypto asset is. There's plenty of material online for that. We'll be talking specifically about in the context of fraud actions. And then we'll be doing our best to gaze into our crystal ball and see what future trends there might be in this sphere, both this year and beyond. So, without further ado, I'll hand over to Kirsty.
Thanks, Ali. Good morning, everybody. So if we just start almost before you're appointed as a liquidator in a winding up proceedings and look at, following winding up proceedings and look at provisional liquidators and receivers. Now, with provisional liquidators, I'm sure you all know that this is something that an office position, that is appointed after an application to the court, either under section 135 for a provisional liquidator or section 286 for a provisional receiver of the Insolvency Act. And that order of the court, if the court is with you on the point of a provisional liquidator or receiver being appointed, does include the details of the functions to be carried out by the provisional liquidator. Now, that's important because provisional liquidation, being appointed as a provisional liquidator, is a method by which the company can be controlled by an office holder while still continuing to trade, and whilst winding up procedures are being considered. So what does that actually do? It has the effect of displacing the directors, in effect, and ring fencing and protecting any assets of the company. Now, the primary reason why a provisional liquidator might be appointed is if there's some indication that upon winding up, the assets of the company might be in jeopardy. So some alarm bells have started to ring at this point, and things are starting to look a little bit shifty. Now, because the appointment is obviously before winding up, then there are certain powers that a provisional liquidator doesn't have, and that is bringing claims for wrongful trading, trading at an undervalue, or preference claims, and that's because those powers arise on the making of a winding up order. So we can start looking into potential fraudulent activity even at a point before we've got to winding up proceedings. Ali, if I could have the next slide, please. So once we've decided that winding up proceedings are the suitable way to go, then we'll look at what the powers of the trustee and the liquidator. So, as you all know, and without teaching you to suck eggs, liquidators are obliged to investigate the manner in which the company's affairs have been conducted. And that's quite a wide power where you can look at various different aspects. Now, the starting point of a liquidator should be one of neutrality. You should be thinking, okay, unless you've come from a provisional liquidator position, you will enter the company and start thinking, okay, well, let's just have a good look around what's been going on. If you've come from that provisional liquidator position, then you might already have a good understanding of the areas that you want to have a look into a bit more detail, the areas where you think you might have a claim, and you might start talking to us as legal representatives. So if a director isn't playing ball with you, won't come to the table and answer any questions, won't fill in the questionnaire appropriately, then there is a power under section 236 of the Insolvency Act to go to the court and ask the court for their assistance, and get the director to appear for questioning in front of the court. But section 236 also goes further than the directors, and specifically states that anybody suspected of being in possession of company property or may have information as to the dealings of the company can also appear before the court for questioning. Now, that's an important aspect which we'll come on to look at in respect of fraudulent trading in a few minutes' time. So it is really useful and something that can extend much further than just the directors, that line of questioning. And the case of Aquila and CPS, which was in the Supreme Court in 2021, is a case where, again, it shows that the powers of the liquidator can go much further than just in respect of trying to recover assets that a company has lost. Now, I won't go into too much detail on that case because I know James Morgan QC is doing a talk on misfeasance on Friday, and he's going to go into some detail on Aquila on Friday. So it might be a useful topic and discussion for you to join and have a look at on Friday as well. Ali, if you could have the next slide, please.
Thank you very much. A seamless link for James's talk on Friday, which I'm sure he'll be very happy with. I'm going to talk briefly about Section 423 claims. I think they're criminally underused in the course of ordinary civil litigation. For some reason, they seem to be a bit of an ugly sister that's just left there, but they really shouldn't be, because I think they're a very useful tool in civil fraud actions. So respondents to a Section 423 claim tend to take the word defraud quite personally. It's a bit of an emotive word. But actually, this isn't a provision which requires a finding of fraud. It has two elements to it. And the first is that there's a transaction at an undervalue, so that the defendant's given away an asset for nothing or for much less than it's worth. That's pretty simple. The real battleground tends to be next. the transaction at an undervalue has to have been carried out for a purpose of either putting assets beyond the reach of a person making or may at some time make a claim, or otherwise prejudicing their interests. Now, putting the assets beyond the reach of a person who is making a claim is pretty easy to identify. There'll be a letter of claim or there'll be proceedings on foot. But who is a person who may at some time make a claim? Well, if you're a claimant in a fraud action, you become a victim of this transaction. So you fall into this category at the point where your cause of action accrues. So when the wrong is done to you that then gives you the right to later on bring an action, you become a person who may at some time make a claim. So it's pretty early on. And the classic case of a Section 423 is where your dodgy defendant receives a letter of claim from you or some pre-action correspondence, obviously has wind that you're going to be going after them, and then starts giving away assets to friends and family. And so you wipe the floor with them at trial, and then you find that the cupboard's bare when it comes to enforcement. So with the Section 423 claim, you can go after not just the defendant, but all of the people who received their assets. There is a common misconception, and I think it's probably fair enough because this is a provision that's in the Insolvency Act. The common misconception is that there requires an insolvency event before you can bring a claim under Section 423. That's not the case. You can do it any time, and that's why I said earlier on, I think it is pretty underused in litigation generally, because you don't have to wait until years down the line. So let's have a look at the second limb of that test then, about the relevant purpose. So what does the purpose mean? And the classic case is the Inland Revenue Commissioners and Hashmi from 2002. And the Court of Appeal said that it's really important to distinguish between a purpose and a consequence. So just because a certain course of action has a certain result, it doesn't mean that that was the purpose. If I go and boil the kettle in a few minutes' time, it might steam up the window next to it. That will be an outcome, it will be a result, it will be a consequence, but it won't be the purpose, because my purpose was to make a cup of tea. The Court of Appeal were very clear about that in Hashmi, and they said that this distinguishing between purpose and consequence applies even if the consequence was foreseeable or was actually foreseen by the debtor at the time of entering the transaction. Now, while the Court of Appeal says that's not in itself enough to find a purpose, you can probably get an inference. If somebody knew that that was going to be the outcome, you can ask the court to draw an inference that that was actually their purpose. But it's not quite as simple as that. And there was a case a couple of years ago which went a little bit deeper into it, which was one of the many JSC and Ablyazov judgments. So I said here, beware the dual purpose case. There are going to be situations where taking an action is done for more than one purpose. But the warning on this particular case, and I think the warning generally across Section 423s, is that just because something looks questionable doesn't necessarily mean that the court is going to find it to have been a Section 423. I'll very briefly tell you about the facts of this case. And if for those of you who are familiar with Eastern Bloc litigation, you'll know that Mr. Ablyazov took a few $1 billion from the Kazakh National Bank and ran away to London with it. Now, this particular case involved Mr. Ablyazov finding time to give £1 million to his son, who was a minor at the time. And the dodgy thing about it was, so it seemed, that he made the transfer a couple of weeks after he'd been to see solicitors about the large claim that was being intimated against him. So far, so dodgy. But in fact, at first instance, the court found that the actual purpose of that transaction was so that his son could get one of those golden visas that we've been hearing about so much in the news recently. You have to have a certain amount of money in your bank account and then you get your visa. And so the claim failed at first instance and it failed again on appeal. But what was interesting about this case was the Court of Appeal said, in situations where you have two purposes for a transaction, you can actually pick either one for bringing a claim. You don't need to prove that what was being done was for a predominant purpose. There's no such wording either in the statute or to be implied into it. There is one other aspect of it which perhaps acts as a little bit of a handbrake for fraud litigants here. JSC made the, I suppose, understandable submission at trial to say, well, Mr. Ablyazov Sr. has been proven to be an inveterate liar in all sorts of different proceedings, both here and abroad. And so when he tells you that the purpose was to try and help his son rather than to do creditors out of some recovery, you shouldn't believe him. And the court rejected that. Being a liar for one purpose doesn't mean that you're a liar for another purpose. So however dodgy things look, in the end, you're still going to need to look at the question of purpose based on the facts and not necessarily just on inference. So having understood all of that, what are the pros and cons? Well, I think there are plenty of advantages of bringing a claim without an insolvency event having taken place. If you did, as a creditor, try to bring a claim under 423 in an insolvency, you need the court's permission under section 424. Outside insolvency, you don't need that permission, so it's one fewer hurdle. You get to retain control of the litigation. You get to make your own decisions on how to run it as opposed to the office holder doing it. And you get to retain more of the benefits of the litigation as well. The contrast being that, of course, within an insolvency, you'd first of all have to account for the office holder's costs and expenses, which you wouldn't have to do outside insolvency. On the other hand, if you bring it after an insolvency event, the office holder takes responsibility for the costs and so on. So you can sit there as a creditor and take the benefits of it if they come in. But also the office holder has those greater powers of compulsion that Kirsty was telling you about just a few minutes ago. So do keep that in your armory next time you are a claimant in a fraud case, because it might just be the thing that makes a difference at recovery. I'm going to hand over to Kirsty now, and she's going to talk to you about fraudulent trading.
Thanks, Ali. So fraudulent trading then, there are sort of two limbs to fraudulent trading were the civil aspect and also the criminal aspect. So the criminal aspect is in section 993 of the Companies Act. And for a criminal offence to have been committed, the company doesn't actually need to be in the process of being wound up. And there are various penalties, fines and prison sentences that can be handed down if found guilty. Now, my expertise is more in the civil aspect of fraudulent trading. So I'm going to focus on section 213 of the Insolvency Act. Now, the subsection 1 sets out, if you like, the conduct that the court is looking for. So that the company has been carried out with intent to defraud creditors. Then if we go on to subsection 2, so the next slide, please, Ali. Here we're looking at, this section sets out who is liable for fraudulent trading and what they can be liable for. So the key words here are knowing parties to the carrying out of the business, and they can be liable to make such contributions to the company's assets as the court thinks proper. So the key there is the knowing aspect of the parties, and it can also be invoked by future creditors of the company. So I think we're all quite familiar with how fraudulent trading plays in with directors of the company, but there have been a couple of key decisions in the last year or so which look at those outside the sphere of directors. So dealing with Bilter first, Bilter UK Limited and NatWest Markets PLC. Now, this was a case where the traders were found to have been party to fraudulent trading. Now, effectively, what happened here was there were a series of intercompany transfers, and in those transfers, there needed to be an account for VAT. But the traders, what was alleged was that the directors were misapplying the VAT and that the bank effectively had liabilities to HMRC. Now, those directors were assisted by two particular traders, and the traders were aware that VAT needed to be accounted for on these transactions, but that it wasn't being charged, and therefore what the judge found, and I quote, that their evidence was untrue, implausible, and designed to falsely suggest that there was no reason why they should not have made the connection between the increase in trade and the fact that it was possibly connected to the VAT fraud. So there, the judge was just not impressed at all by any of the evidence that the traders gave. and stated quite firmly that there was this knowledge that what they were doing was wrong, the knowledge that the VAT should have been accounted for, and although they weren't personally misapplying the VAT, that their actions were assisting in this fraudulent trade. And they were found liable and had to contribute. Now, that I will say that that is a case that has been appealed, but the appeal hasn't actually overturned that decision in that respect. It's been appealed on something else. In respect of Bisco, now this goes even further than employees, and the defendant here was a consultant of the company. The court did find that actually he was in effect a de facto director of the company. The company in this case ran an investment scheme funded against financial institutions for the mis-selling of bonds. And what would happen was the investors would invest money and the company would use those investments to fund claims. If the claim succeeded, the claimant would receive compensation, less a success fee, that the company would keep and split with a claims management company, and then the investor would receive a fixed sum in return. If the claim failed, then the whole claim would be covered and the cost would be covered by the insurance. What the judge found was important was that at the outset, the company had no working capital and relied on receiving large sums from the investors. And the company knew, and the directors and all those involved that knew, in return for those rather large investments, the investors would only be receiving modest sums in return. When the company went into liquidation, the deficit was said to be about £2 million. One of the key factors in this case was that there was a brochure that was sent out to investors that had very serious misrepresentations in it. And the respondents in that case, and particularly the directors, the respondents were the directors, other de facto directors, and a consultant, and various other companies. Now, many of the others saw what the writing was on the wall and settled. But Mr. Milner, who was the consultant, refused to settle, saying, well, I'm a consultant to this company, it's nothing to do with me. I didn't have any control of how this company was run, and it's not my fault, effectively. As I say, it was argued that he was a de facto director, and that he had breached his duties and was responsible for both fraudulent and wrongful trading. It was found and held by the court on that instance that the consultant knew about the brochure. He knew that brochure, in fact, he more than knew about it, he'd had a very large hand in actually writing the brochure, and knew that there were very serious misrepresentations in that brochure, and that in effect this scheme was fraudulent and dishonest. Now, if you do read the case of Bisco, you'll see that there is a lot of material on wrongful trading also, and it does show the interaction between wrongful and fraudulent trading. But this just goes much further to demonstrate that those who are deemed outsiders, in inverted commas, can be liable and have to contribute to the company. Ali, if we could have the next slide. So the pros and cons of fraudulent trading. Now, Ali is going to speak to you in a moment about wrongful trading. So there is an aspect of looking at fraudulent and wrongful trading together. But the pros of, if you were going to consider a fraudulent trading claim, it can be assigned by the office holder. So if there is someone who has been seriously wronged and the office holder doesn't have the appetite, doesn't want to have the costs of bringing a fraudulent trading claim, it is something that can be assigned, and a third party effectively can have the cost of that litigation. And as we've seen from both Bisco and Bilter, then there is a much wider scope than just the directors to assist with swelling that asset pool. And this might be where you're questioning under section 236 plays hand in hand, that you think, oh, well, there's an employee over there who seems to have some knowledge, or they must have known, or they've assisted in some way, and that's where your scope of questioning can also widen your scope of fraudulent trading. And the very obvious con, and I think that many people are aware of, and why people tend to sort of go running from a fraudulent trading claim, is that it can be very hard to prove, because there has to be that element of intent. And if you are going to plead a fraudulent trading claim, because you need to identify this intent, you must identify and plead the dishonesty very clearly in any statement of case. And also that dishonesty must be put to the individuals on cross-examination. So you've got to be very, very clear on the conduct that you're complaining of, and the knowledge that those individuals had, and that there was that very clear intention to defraud creditors. And without much further ado, I hand over to Ali to talk to you about wrongful trading.
It's the slightly less difficult thing to run. Obviously, these are all for scenarios where, for example, in a fraud claim, your defendant is a company and you're pretty clear that the assets are not going to be enough for your recovery, and you want to pursue the director personally and introduce a bit of pain into their life as well. Wrongful trading, section 214 is the next one along. It's where a director can be ordered to pay back into the insolvent estate the losses that he or she caused by deciding to trade the company, even when it was never going to be avoiding insolvency. So here it is there. It can be brought against a director which has entered insolvent liquidation. So this is something which obviously happens down the line. And in scenarios where before the winding up of the company, that director knew or ought to have concluded there was no reasonable prospect that the company would avoid going into insolvent liquidation. This point of no return type of argument is classic trial territory. Obviously, it will require a decent amount of expert evidence as well, unless the accounts are blindingly clear. And the court won't make that order if it finds that the director took every step with a view to minimising the potential loss to the company's creditors as he or she ought to have taken. Now, you'll notice the words there are every step, not all reasonable steps or anything, it's every step. So this is where the interplay potentially with civil fraud comes in, because if you've got someone on the other side who is obviously a fraudster, whether it's been proven in other proceedings or whether it's plain from the facts here, judges have a very wide discretion on finding what every step actually means. And if you're on the side of the angels, I think you're more likely to get a judge to find that, yeah, the director may have taken some steps, but not every step to avoid it. And so that hurdle isn't overcome as far as the director is concerned. A lot of this comes down to judicial discretion. So then when we look at this question of knew or ought to have concluded that there was no reasonable prospect, what does that mean? What does the court take into account? The court takes into account this: the factors that would have been known or ascertained or reached or taken by a reasonably diligent person having both the general skill, knowledge and experience that someone in their position would have had, and also the general skill and experience and knowledge that they in fact did have. So there's an objective standard and also a subjective standard. And once again, the judicial discretion comes in because directors are often able to fight it on limb B there, play dumb, and say, well, you might say that I should have had X level of knowledge, but in fact, I'm really inexperienced and my trade is something completely different altogether. And so my level of knowledge was much lower. Query what that does to their general director's duties of being able to run a company properly. But leaving that to one side for a moment, if you're on the side of the angels, generally speaking, a judge is going to be more likely to find on limb B that your director isn't quite telling the truth and probably isn't letting on exactly what they did know. So wrongful trading, it comes down to really being able to identify the amount of loss that's been caused by trading past the point of no return. What are the pros and cons of it? Well, the pros, as Kirsty has already said, can be assigned by an office holder. Cons are, it's often a tough claim to prove because you have to have the knowledge about the point of no return and proving when that point of no return was. There's the question about whether the director took every step. And then there's, of course, the double standards of knowledge to be imputed. So what does the reasonable person in that position know about what they can see, and what in fact did the director know? These are often questions which really are difficult to tell and often come down to witness evidence. There is, of course, an additional complication with wrongful trading. For those of you who are paying attention at the start of the pandemic 2 years ago, you'd have noticed that on one particular day, the business secretary, Alok Sharma, pushed Chris Whitty out of the way and took the lectern for himself, and announced that wrongful trading would be suspended throughout COVID to try and help those honest directors who were doing the best they could in difficult circumstances. So that went from the 1st of March 2020 all the way through to the end of June 21. There is the presumption that a director is not going to be liable for wrongful trading. But actually, is it any different? Because wrongful trading is still wrongful trading. If you're guilty of it during that period, the presumption against wrongful trading will probably be rebutted. But what it does at the moment is it adds that additional layer of complexity to an already pretty challenging way of doing things. So that's section 1 dealt with. That's the longest part of the talk. We're now going to go on to the second part, and Kirsty's going to talk to you a little bit about disqualification proceedings.
Thanks, Ali. Yes, so directors' disqualification proceedings then. The relevant statutory regime is in the Companies Directors Disqualification Act 1986, quite a mouthful, the CDDA for short. And that should be read alongside the relevant parts of the Insolvency Act. Now, where does this come into play? So if upon investigation, the liquidator considers that there's been a breach of director's duties, an application for director's disqualification may well also follow. Now, the aim of disqualification is said to protect the public. So if the directors of the company are so unfit that they should not be concerned with the management's formation or the such like of a company going forward, then the court must disqualify that individual, and that power comes from section 6 of the CDDA. Now, the effect of a disqualification order or even an undertaking, if the director holds his hands up before you get to court and says, yeah, okay, I'll agree to not be a director, is that the director cannot participate in the management, promotion or formation of the company without leave of the court. Now that's quite wide. That covers situations, for example, where they set up another company in spouse's name, for example. And thank you to the person who's just pointed out there's a typo in the slide. We'll correct that before it comes out to you in our pack. So in addition to this application for a disqualification, the Secretary of State for Business and Enterprise may also make an application to the court for a compensation order, and that power comes under section 15A of the CDDA. Now, the Secretary of State is unlikely to seek a compensation order based upon the same facts of potential or existing litigation, and that is to avoid the director being held liable for twice for the same conduct. So this compensation order might be useful, for example, not to have two bites of the cherries, but you may, on assessment of your claim, think, well, this is a stronger aspect of the claim that we can go forward and where we've got better prospects of success on running through to trial, where the costs are likely to be higher. And there may be an aspect that you may, on assessment, think, well, the merits of that are slightly less. If the Secretary of State wants to go forward with a compensation order, then we will leave that aspect for the Secretary of State. It's not that you're leaving it behind or whatever, you just don't think that your prospects merit the costs of running something potentially through to trial in either a fraudulent trading, wrongful trading, or any other action against the director or members of the company. Now, paragraph 3 of the section 15A sets out the conditions that need to be fulfilled in order for a compensation order. And that is that the individual must be subject to a disqualification order or an undertaking, and that the individual's conduct has caused loss to one or more of the creditors of an insolvent company at the time at which he was a director. So you can go back and directors who have resigned, for example, they can be held liable under compensation orders and make a contribution. Now, previously, what we've seen is that compensation orders were for those companies that were insolvent and had gone through an insolvency process. And if you could just have the next slide. So the Rating Coronavirus and Directors Disqualification Dissolved Companies Act 2021, again, another mouthful, has broadened that scope. And essentially, what can happen now is that compensation orders and disqualification proceedings can be brought against directors of companies where there hasn't been an insolvency situation. So you may have a company, for example, that has been wound up by the directors and hasn't gone through that formal liquidation or insolvency process. But there may be conduct that has caused loss to creditors, and the director should be disqualified for the protection of the public. And you can ask the Secretary of State there to have a look and see if any disqualification proceedings or compensation orders should be made against those directors. Now that power is 3 years from the date of dissolution, and that is really quite useful because it saves having to restore the company and then go through an informal insolvency process in order to achieve the aims of the Disqualification Act, either to get a director disqualified or to seek any compensation orders. So effectively another string to your bow when looking at potentially fraudulent activity by the directors of the company. Over to you, Ali.
Yes, we'll see how many of those declarations of solvency before a company's dissolved actually turned out to be accurate. Right, now for something completely different. Third of our 4th topics is going to be crypto assets. You can't move online without hearing something or other about crypto. Everyone's got something to say about it. I'm just going to be talking about it in the context of fraud claim and in particular the insolvency aspect of it. First piece of good news, the courts seem to be accepting pretty much on spec now that crypto assets are property. Now, the task force's paper from 2019 seems to be the bedrock of lots of judgments, which are now making it quite clear that crypto assets have all the hallmarks of property. So they are identifiable, definable, they have some degree of permanence, and they're capable of being assumed by third parties. And I think the starting point for any assertion that a crypto asset is indeed property is Mr. Justice Bryan's decision in AA and Persons Unknown. I think we can pretty much take it as read these days that by and large crypto assets, certainly the more mainstream ones, are going to be defined as property. So if it can be property, can it be a trust asset? Well, a very recent decision of the High Court, a deputy judge sitting Wang and Derby. Now, in that case, the decision was that actually on the facts, a trust wasn't established because it was a sale or buyback situation with some cryptocurrency that didn't have the hallmarks of a trust. But very importantly, the court found that actually in the right circumstances, a trust can very well exist when we're talking about crypto assets, which is great because, of course, if you do establish that there is a trust and that you are the beneficiary, you find yourself in a much improved position in the event of an insolvency. You skip the queue of unsecured creditors and you get yourself ahead. So that's all good so far. But what about if you want to freeze an asset? you need to find out where the asset is, and that's what the courts are calling the lex situs. So again, we have to tread a little bit carefully with the question of lex situs at the moment, because it's still very much a developing area of law. But generally speaking, if you are based in England and you do your trading in England, and you buy your crypto when you're in England and it gets whipped away from you when you're in England, it's kind of hard to find where the asset is and who the person is who has it and where they are. So the courts are being a bit more cooperative now than they might otherwise have been, and are tending to find a bit more that lex situs could well be in England if that's where the aggrieved person is. A couple of recent decisions. It was Judge Pelling in the case of Fetch AI, and it was Mr. Justice Butcher in Ion Sciences. Both of them found that the lex situs of the crypto asset there was in England. They both made it painfully clear that these were cases that turned very much on their own facts, and they shouldn't be taken as any general propositions of law. That's for the Court of Appeal to do, and that's probably fair enough. But after a while, you start to build up a bank of first instance decisions that come to the right result, and they all say, well, we turn on our own facts. You'll be able to start linking the facts of your case to those ones and saying, well, yes, that's fine, that turned on its own facts, which are primarily the same facts as ours. So that's good news for claimants in fraud actions, because it means that you may well be able to get freezing orders in the UK. And if those assets are located before they're dissipated, you might be able to establish that there's a trust, that you're a beneficiary, and that if there's an insolvency event, then you are at the front of the queue. So that's all very well if you're a litigant. What about if you're an IP? Well, IPs obviously have a duty to investigate and get in the assets and get the best value they can, which these days is likely to include cryptocurrency as well. So IPs, I think, are going to have to be turning more and more to crypto experts, the real crypto experts, not the self-appointed ones, to try and track down where the asset is and how best to get hold of it. Because, of course, the asset holder needs to be identified together with the public and the private keys, which are the two codes that you need in order to access the value in the asset. It's not just as simple as getting an order against the bank to freeze things, because cryptocurrency exchanges don't actually hold the asset. They are simply an intermediary for this trading to take place. So you do need that level of technical expertise to get you over the line to find where the asset is. Often you won't. Often you'll have to get orders against persons unknown. There's a lot of learning out there about how to do that. Courts are very willing to do it if you're able to identify a category of persons unknown. So, for example, the people who transferred out asset 1, 2, 3 on a certain date, that's absolutely fine. There's no problem with doing that. If you can locate it, obviously so much the better. The other reason why I think crypto experts are going to be quite a necessary tool for IPs to use is because at some point, once you've got the asset, you've got to sell it. Now, cryptocurrencies, in particular Bitcoin, have fluctuations which are quite wild in terms of their value. They really do go up and down. So what you wouldn't want to do as an office holder is to sell a Bitcoin for £20,000 this week, where if you'd taken proper advice, you've seen that actually you ought to wait for it to go up to its median value of £30,000 or £40,000 or something along those lines. Leaving it all in non-expert hands is a bit of a risky business. So that's all well and good. What are the authorities doing to help us out? Well, a couple of weeks ago, Sir Geoffrey Voss told us that the government is planning to draw up some plans to make it easier for courts to trace crypto assets, which might include obligations on crypto exchanges to disclose documentation on individuals proven to have taken part in frauds. I think that's probably riddled with problems. Crypto assets are generally a bit of an unregulated Wild West. Exchanges and indeed holders of assets are going to be based in many different jurisdictions. Quite how we're going to get a set of plans applicable in the UK only, which are going to be able to help claimants track down things from all around the world is beyond me, but it wouldn't be the first government scheme to have a nice headline, but probably not too much meat behind it. So as with all of these things, let's wait and see. Final topic, and the timing is going pretty well. I think we will stick to our promise of having you back to your emails for 10:30. Future trends. Well, this is just Kirsty and I's best guess at what's going to be hot topics for the next year or so. Be interested to see what you think, if you've got anything to put in the Q&A or the chat about it. I think the first area is going to be in relation to ESG. For those of you who don't know what that is, that's environmental, social and governance. So sort of someone like Jeremy Clarkson would describe it as do-gooding. And just like every, I suppose, chocolate bar and sausage roll and can of pop is going to tell you that it's packed with protein to make you think that it's a healthy choice, every investment or corporate branding is going to be telling you now that it's green or environmentally conscious to make you feel a bit better about ploughing your well-earned money into it. So what if it turns out that, shock horror, some of that turns out to be just complete greenwashing, a whole load of nonsense? Might be in relation to victims of investment fraud, but in the end, a lie is a lie is a lie, whether it's ESG related or whether it's not. There's still going to be consequences for it. But I think there is one particular aspect of ESG which might be quite interesting in the insolvency sphere, which is how far does ESG become relevant to a director's duties under Section 172 of the Companies Act to promote the best interests of the company? Now, the mood music at the moment, I suppose, seems to be that of course has to be part of it. Everyone's best interests are served, not just the companies, by being ESG aware. And you'll have seen perhaps that there is a claim which has been issued against members of the board of Shell for their apparent failure to pivot the business to a more sustainable way of trading. But generally, the idea that directors should be doing good is taking off. But what about this? What about the situation where making ESG-focused decisions actually leads to a reduction in profit? What if it's actually not profitable to do right? What if drilling holes in the ground and chopping down trees makes more money for a company than not doing that? At the moment, the answer is wait and see. There's no real cases which are going to give us the answer right now. But I think it's an interesting thing which is going to take off, particularly if you have very active shareholders like the ones in Shell, who are going to be pushing their directors to take a certain step where others might be wishing to just see pound signs. So, well, let's wait and see on that one. Kirsty's going to talk to us about COVID-related fraud.
Yes, thanks, Ali. This is a little bit like closing the barn door after the horse has bolted, because I think we all sit here and think, well, actually, okay, we understand perhaps the government needed to help businesses, but there was absolutely, and I think we can all agree, absolutely no due diligence undertaken before large sums of money in some cases were effectively handed out. So in order to sort of redeem itself, the government has started to ask the Insolvency Service to look into some of these matters, and the Insolvency Service has begun to petition the courts to wind up companies involved in abusing government scheme. Now, if you were to Google COVID-related fraud, you might see that there are some stories that crop up, and those stories that crop up in the media, on the Insolvency Service website, are potentially what we could call big ticket cases being reported. So one of the first cases saw a director being disqualified for 12 years after he transferred the full amount of the company accounts, being a bounce back loan, into his own account days before the company entered into administration, and effectively forging a document for his bank. So I don't think the Insolvency Service had much trouble there. There are also cases where the company has effectively no legitimate business activity for a number of months or even years before COVID loans were applied for. And one of the big ticket items reported in the Insolvency Service website demonstrates that actually they successfully recovered sums from a director who had secured a loan on false information. And I'm sure we're all familiar with the idea of people setting up bogus companies in effect to claim COVID-related assistance. Now, the Insolvency Service and the government, obviously because they've realised they are the masters of their own misfortune in this by not undertaking any due diligence, are asking us as the public to tell tales and inform the Insolvency Service if they suspect directors have wrongly taken COVID-related loans. That could be potentially quite difficult and could potentially lead to a series of misinformation being provided to the Insolvency Service, and whether they have the time to investigate all of those matters is another thing entirely. So what the relevance of the new 2021 Directors Disqualification Act is that actually the Insolvency Service can also now investigate bounce back loans where a company has claimed bounce back loan, for example, hasn't gone through that insolvency process but is now dissolved, and the directors have had 50,000 or however much of taxpayers' money in their pocket and disappeared off with it. So that's all about the Insolvency Service and the work that they're doing to try and redeem some of this money back into the taxpayers' pocket, or funds rather. But what about the duties as a liquidator or an administrator? And looking at these claims in misfeasance, for example, and wrongful trading. Now, I've done a couple of cases recently where this has started to trickle through. So in a recent case, the company had gone through a winding up procedure, and the liquidator uncovered a bounce back loan that had been wrongly taken by the director. He had siphoned that out into his own funds, and the liquidator commenced misfeasance claims, section 213 and section 214 proceedings, but the director there, as we were getting sort of further down the line, just held his hands up and said, yeah, I'll repay the full amount, actually, which is quite remarkable for a director. What's important there was actually that was the only bit of misfeasance or bad behaviour by the director that the liquidator could uncover. Pretty serious, but obviously, you know, no excuse, but his sort of desperate times. He was saying that he hadn't been paid through the business, he'd lost a lot of money personally, so he thought that actually he was entitled to take this money. He hadn't properly understood what the bounce back loan was for, and when it was pointed out to him, well, it wasn't for you to just pocket because you felt like it actually belongs to the business. He was quite happy, well, not quite happy, but he held his hands up and gave it all back. Now, as I say, the Insolvency Service are highlighting the very big ticket items that they are being able to recover. But the reality is that actually many of these COVID frauds are thought to estimate about £30,000. So there does come into question, and I was indeed on the very sharp end of a judge's tongue recently when I was seeking remuneration for an office holder about the cost of recovering COVID-related fraud, where the value of it is, I say in inverted commas, quite low. Now, what happened in this other case of remuneration to the office holder was the judge was of the view that actually the office holder's fees and that of the lawyer who'd assisted him had essentially outridden any recovery that had been made on that COVID-related fraud. So that there's the age-old question of, do the costs outweigh the benefit? I do think because of the public policy elements of this, it is actually something important that is pursued. Judges may have their view, but then I suppose it's for us as lawyers to consider the financial viability of those claims and whether we proceed going forward. Now, one of the things that Ali and I discussed when we were talking about doing this talk was actually if we can see that there are a series of companies that are connected entities and have relevant common directors, and you can see in one company that something has happened in relation to a COVID-related fraud, looking at collective appointments over collective entities. So because you've unpicked something in one company, usually it's gone on in another company if the directors are common. So is there something that makes the potential value of recovery better because you're looking at, I don't know, 3 or 4 little companies and being able to recover 15, 20, 30,000 in respect of all of those. So that's something to consider. But I do think over the next year or so, we'll start to see a lot more COVID related elements into recoveries for directors, misfeasance or potentially fraudulent activity in the company.
Fantastic. Very last thing, just want to whip through is something which is on the horizon. It might not happen this year. It's only at white paper stage, but the government's launched a consultation on the reform of Companies House. So at the moment, of course, Companies House is something of a passive receptacle of information and that it lays out nicely on its website for you to go and have a hunt around at. The proposal from the government is that it changes to being more of an active gatekeeper. So it takes a bit more of a live role. So why is that? Well, we all know that actually information at Companies House can be used and abused. And the proposals which are being put forward by the government are that their Companies House has the power to query entries, has the power to remove entries if it turns out that they're not accurate. And of course, at the point where Companies House then removes entries, there are going to be suddenly gaps in a company's records which need to be filled if they're to not fall foul of the Companies Act. You can well understand it. I saw something on LinkedIn the other day. There was a solicitor particularly upset about the fact that there is a director who remains on Companies House with the name of Adolf Tooth Fairy Hitler, and nobody appears to have taken this down. So that kind of thing, if the government gets its way, is going to change. How are they going to do this? They're going to use the type of enhanced ID checks that you're probably going to need to use a lot more when you're opening bank accounts or getting a passport, that type of smart technology. Restricted use of corporate directors so that you can't have shells within shells within shells. Again, to improve the transparency of being able to use the information on Companies House. And I love this very ambitious thing at the end where they say they're going to be introducing intelligence sharing with other government departments. I've literally never seen that work in any government department ever, but there we are. And also sharing them with IPs, which could be a very useful thing if they manage to get that off the ground as well. Why are they doing it? Because they say it helps prevent international money laundering, helps protect the public from sophisticated fraudulent activity, and it boosts enterprise by lowering risk and improving the reliability of data. All very laudable. I'm just going to politely say, let's see what happens. So thank you very much for sticking with us. This might be the first time in the history of mankind that a barrister said that they're going to speak for an hour and actually does. But if anyone has any questions, now's a good time to do it. But otherwise, thank you very much for sticking with us.